have one more case before we have the morning break, which is MAHLER versus MAHLER, 2018-0186.
I think they're just right outside.
Okay. You can have a seat. Are you appearing in the case of MAHLER versus MAHLER? Okay. Good morning. Since I don't think either one of you were here when we introduced ourselves in the beginning of the session, we also went over the rules just to remind you that you each have 15 minutes to make your argument, that we've already reviewed the transcript and everything that you have provided to us, and there is no rebuttal after each side has concluded. Okay? Good morning. Yep, right. Thank you.
Your Honors, it's a privilege to be here before you today. I would like to just acknowledge the respect and appreciation that's due the probate and family court judges of the trial courts in the Commonwealth of Massachusetts. Our probate and family court judges are tasked with the challenge of deciding issues that impact the most intimate issues, parts of the lives of the citizens of this Commonwealth, compared to other practices of law.
Yeah, we know they have a very tough job.
Yes, yes.
Can you tell me, there was a modification last year, and that dealt with parenting time, is that correct?
Yes, Your Honor, there was a stay that was granted in the appeal so that appellant could go back to the
No, I understand the procedural posture, but did it resolve any of the issues that are before us?
Yes, in fact it did. So one of the issues that was resolved was...
Can you move that microphone closer to you?
Yes. One of the issues that was resolved was the child support issue, Your Honor. The parties were able to adjust the child support in accordance with the 2017 child support guidelines. So any of those issues relating to child support, I think at this point have been resolved, yes. The issue of parenting time, I think, has also been somewhat resolved. There are protocol in place now based on the judgment of October 2018.
But you don't raise an issue on parenting time?
Correct.
Okay.
So really it's just the legal custody and some of the property division issues, I think, that are still outstanding.
Okay.
The property division issues, and what else is outstanding?
The legal custody of the two minors.
The legal custody?
Yes.
Okay.
So that still involves the guardian ad litem argument?
Yes, it does. The appellant challenges the guardian ad litem, the judge's rejection of the guardian ad litem report, essentially. It's just arguing that there's really not sufficient findings in the judgment to, as far as how the judge considered that evidence. There was trial testimony in the guardian.
He said it was helpful and informative, but he wasn't going to use all of it.
It didn't even go that far, Your Honor. He just simply stated that it was helpful and then proceeded to completely reject the recommendations that were made by the guardian ad litem regarding custody.
And she testified, right?
She did. She was at trial, Your Honor. She testified.
Subject of cross-examination, and the
Yes.
judge is making credibility determinations. And
correct.
He decides not to credit some of what she says.
If that were the case, Your Honor, it's not written explicitly that way in the judge's findings.
What is the case that requires him to be so explicit?
Your Honor, there is. If you look at the cases that discuss GAL's recommendations, particularly McKnight, Belanger, and Vitano, that was from 2017. If there's contrary evidence in a guardian ad litem report versus what the judge's findings and ultimately decision is, the judge should face that that contrary evidence and make explicit findings regarding why the judge has made the decision not to adopt those recommendations. There was a recent case called McKnight v. Fisher in 2018 where the court instructed probate and family court judges to make positive findings to support the award of shared legal custody in cases where, and also physical custody in cases where a guardian ad litem has recommended otherwise. In that case, there was the guardian ad litem had made...
I mean, doesn't the guardian has concerns about a husband's parenting skills, right?
Correct.
And the judge takes that head on. So he thinks he's being unfairly dismissed and labeled as a parent who lacks basic parenting skills, which is not true at all, the judge says.
I agree, Your Honor.
That's pretty explicit.
I would agree, except that I think that the judge did not go on to clarify or qualify what that actually means. I think that there's also a mention just prior to that in the judgment where the judge is stating that that father has made unsafe parenting decisions. So he recognized in the record that there is a history of father having poor judgment in regard to parenting decisions. And then, again, without qualification, goes on to state that, mother's allegations that there are parental fitness issues is not true at all. I don't know that there's anything in the record to support that. It certainly isn't set out in the judgment.
Well, the husband testified.
The husband testified at trial. The wife testified at trial. The judge didn't make any comments in the judgment.
Then Belanger's going to tell me that the judge has to be that explicit in how he credits testimony.
I think so, Your Honor. I think that it's an abuse of discretion if GAL recommendations are rejected.
So he had to follow what the GAL said?
No, I think that the judge has broad discretion when it comes to weighing a guardian ad litem's report as part of the record, as part of the evidence. It should be considered. It certainly was admitted as trial evidence. However, rejecting it would require the judge to make at least some findings as to why the evidence that is contrary to the ultimate decision was rejected. And I think that's what the case of Mason v. Coleman from 2006 and Belanger versus Vitano in 2017, as well as McKnight v. Fisher, I think all stand for that, Your Honor.
So I guess the issue here really is how explicit the findings were or not, because as Justice Mead has pointed out, the judge here did actually refer to some very specific facts, how the parenting styles are vastly different between these two people, and that the GAL's recommendation was perhaps suspect because of not understanding how different the two styles were, etc.
I think part of my understanding, and I think that it was pretty clear in the trial testimony as well, that the guardian ad litem's investigation revealed that the parties, yes, had very different parenting styles. That was part of the basis that of her conclusion that the parties should not share legal custody, and that mother, as primary caregiver, would have sole legal custody.
The judge did decide also that if the parties are unable to agree on such decisions, meaning all major decisions affecting the children, the decision of the wife shall be binding, subject to court resolution after hearing on properly filed complaint for modification if any decisions made are found not to be in the best interest of the children.
Correct. And, Your Honor, the judge did also go on to instruct the parties to devise their own parenting schedule after the trial. He was not willing to set a specific schedule in the faith that the parties would be able to accomplish that, which in fact never actually happened. The record in the case would absolutely indicate that mother and father are unable to agree and make joint decisions together. They never have. There's no evidence that they have. So asking them to do that was optimistic, to say the least. They were unable to do that. So even the day-to-day basic decision-making. So if mother's decision-making trumps father's decision, if they're in conflict, her decision would be the ultimate, decision-making. So, and that's fine when it comes to bigger decisions like where the children will attend school, whether they'll be homeschooled or, what kind of medical treatment may be necessary. But day-to-day decision-making, it's very difficult, I think, for to have to go to court to seek an order protecting her right to make day-to-day decision-making when they're in constant conflict. I mean,
I take it that when the modification complaint was filed, that there was no request to change the legal custody, or was there?
we reserved that issue for the appeal, so that was left entirely to the appeal.
And I saw that in your brief, meaning that this is the exclusive place that issue will be decided, or that you pled it and you're waiting to see what happens?
Yes, Your Honor. The reason why that wasn't included in the modification action was because at that time, we asked the court to stay the appeal to deal with an emergency crisis that was going on.
I understand.
Yeah.
I'm just saying you're not. So
Right.
so this is it
Yes.
for now, unless
Right.
you file a subsequent petition for modification.
Yes, that's correct.
Okay.
I think, ultimately, there were a lot of errors that were plain on their face in the judgment in regard to, the child support issue no longer part of this case, but, you can see the errors made there. The property division issue of award of the marital home is a very important issue to my client. I think it follows naturally from an award of sole custody of the children and mother being the primary caretaker of those children, that awarding her the marital home as a part of the division of marital assets is critical, particularly where you have a child who has significant mental health issues and requires even that much more support and structure and routine and security for mother to be able to reside in the marital home with the minor children is absolutely in their best interest. I think it naturally follows, even if it's considered a form of support, which is something that is absolutely mentioned in Hartog v. Hartog from 1989, even as that far back. The court considers award of the marital home to the primary custodial parent an important form of support, particularly in a case like this where there are not a lot of valuable assets. The marital estate itself is modest. Mother at the time of the trial was not working. She did not have a significant source of income to speak of whatsoever. And I think it would.
The judge did consider all the factors, and I think you'll admit the distribution is pretty even.
The distribution was even, but for the fact that the judge did not consider, and there's not any mention of in the judgment, her liabilities. So at the time of the trial, mother's salon business had just closed, and she had lost that source of income that the parties had relied on throughout the marriage. She was not working. She had no source of income. She was living off of credit cards, essentially. She had incurred in her care of the children and having to move out of the marital home, and in just dealing with the court case and the litigation expense. She had incurred over $20,000 in debt between securing alternate housing, attorney fees.
I'm sorry to interrupt. The equity in the house in Sandwich was only $25,000.
That's correct.
So, but you look at the balance sheet, and the wife's getting over $54,000 in assets.
I think the difference between what father was awarded and what mother was awarded was a difference of roughly $500 or so.
$400, yeah.
But there were certain points that were left out. Father received an income tax refund in the amount close to $5,000. He had received a pre-division of assets of $5,000 already. I think the judge did consider that to some extent.
It's in there.
But also in crediting that $5,000 roughly to father that was given to him as a pre-division early on in the case, I think it only is fair that mother would have been given the same credit. So it's
on the husband's balance sheet.
Correct. Mother spent far beyond $5,000 in expenses related to things directly related to the divorce and their separation. She, again, and being liable for the guardian ad litem's costs and fees, I think was unduly allocated to her, that debt. I think that, if father was allowed to have $5,000 as a pre-division for moving, then mother should have been also given her moving costs and expenses, and that was asked for at trial as well as attorney's fees, and that's not certainly not included in the consideration of the division of property as the judge sets it out in the judgment.
Were you trial counsel?
I was trial counsel, Your Honor.
And you requested an appointment of a guardian for the husband.
There were some issues. Yes, I did, Your Honor. There were some issues.
That was going to be expensive.
Perhaps.
And how did the judge characterize your request?
So that was leading up to the trial date.
How did the judge characterize your request?
The judge characterized it as over the top. And I understand understand the perspective, but I think that mother's perspective was lost in that issue because she was, from the beginning of this case, since I began representing Ms. Mahler, I think she's never said an unkind word about father. She's always advocated for his...
And the judge found that both parties are kind, loving people who truly love their children.
Yeah, so
no one's casting any aspersions.
Right. And I think that in good faith, mother was looking to hoping that father would be able to get the kind of advocacy that would result in a fair trial. And ultimately, that was argued at the hearing on that motion. It's unfortunate that the judge looked at it the way that he did. I think that was a misunderstanding. Mother truly was looking for advocacy for father. He does have the record does show that he does have some degree of disability, and whether or not he was competent to represent himself in a trial was unknown, and she was looking for a determination by an expert to whether or not father was prepared and would be able to have a fair trial given his disability.
So your time's just about up. 15 seconds. Is there anything else you want to tell us?
No, Your Honor, I just would like it to be clear that Ms. Mahler is challenging the judgment in this case simply because primarily she's motivated by promoting the best interests of these children. She's been their primary caretaker since they were born and feels the need to advocate on their behalf, and that's why she's here today.
Thank you.
Thank you.
All right, Mr. Mahler.
Good morning, everyone. My name is David Mahler. Sorry if I'm a bit nervous. I've never...
That's all right.
Yeah.
What would you like to tell us this morning?
Well, I just first of all thank you for being so familiar with my case. It's obvious in the way that you speak, and I appreciate it. It makes me feel a little bit less alone. There's a lot to say over the past few years, but basically as far as the division of assets, if you actually look at it, it was actually unfair to myself because if you look at the balance sheet, it actually shows that he credited sort of the inflated equity of the house, $10,000, because there was a 0%, no interest loan associated with it. But he also said that each party should, take care of their own liabilities. And so that one's actually a joint liability, but it kind of ends up being on my liability, and it effectively inflates my assets. Also, she basically just stole all the money at the beginning, and then, reluctantly gave me some money back at the beginning, and then that was credited to my balance at the end, which is also not fair. I was going to just let things go, but she wanted to do an appeal, and I think too many of my arguments were focused on the kids because, ever since the beginning, she was trying to get sole custody, which to me was absurd because I was the primary caregiver. I left Trader Joe's when Emily was 6 months old. I was with her every day. She continually argues that, other people watched them throughout the years. She's taking multiple different specific data points, and she's almost like just putting them all as if they were at the same time. The kids were watched one day a week. She complained that I would even want 24 hours off. She would come home from work 7 p.m. every night. I felt like a single parent. And then after all that, after doing that for 10 years, and this is during the period where we were initiating the divorce, she says the notion of me being the primary caregiver was a joke, which was one of the most offensive things I'd heard to that point. And that was also during a dinner in which her family was there, and her dad actually tried to invoke violence in me because they couldn't legally get me to leave the house. They couldn't, I had every right to be there, and so they tried to pressure me out. Jess said she would make it, like, really difficult for me to live there. She locked the door upstairs so that I couldn't sleep in that room.
Mr. Mahler, excuse me. This case is partially impounded, so don't use any names. So husband, wife, older child, younger child.
Sure.
Thank you.
Okay. But yeah, trying to invoke violence, and ever since I initiated a divorce, or said I wanted to, she has been trying to marginalize me as a father. She's been trying to make it seem as if she's the better parent, and doing everything that looks good, on the surface, and also just trying to paint me in a bad light in any way possible, without really.
Let me ask you a question, if I
Sure,
may.
yeah.
Do you agree with the counselor that the parenting time issues have been basically resolved?
I think they're on their way. Right now it's Thursday through Saturday, and that's been a reluctant thing for her as well. She keeps claiming we can't agree, but she just simply refuses. She didn't let me have
Let's see if we can move forward. So you would agree that, at least at this point in time, that despite these issues, that the issue of parenting time is essentially resolved.
Yes.
And also the child support issue has also been resolved.
Yes, it has a mechanism for adjusting, but yes, it's been resolved.
All right.
Any other questions? I mean, I feel like.
I think we understand your argument.
Okay.
Thank you for being here. Thank you both for being here, and we'll take the case under advisement. Okay. Thank you both. We have 2 cases left. We'll hear them after the morning break.